Well, it's wonderful to be here with you all. Thank you for coming out and giving me this opportunity to meet some of you and have a chat with you, because this is what I think of this is. I'll say a few things about my experiences in law and about what it's like to be on the Supreme Court of Canada, and then I look forward to you asking questions, and I hope most of our time can be spent doing that, because I always find that the best part of these experiences is interacting with you who are our future members of the legal profession. It's, people always wonder how I came to be a judge. And they say, well, you know, when did you start planning to become Chief Justice? Were you 4 years old or were you 3? And I say, well, you know, I didn't have any idea at all that there could be such a thing as a lawyer at that point. And my life is really just a series of happy coincidences, made possible, I suppose, by diligence and hard work, and above all, a love for the law. I grew up in a small town, did undergraduate in philosophy, didn't know what to do, didn't have a job, thought maybe at some point I should get equipped so I could have a job, and fell into law when the dean invited me, the then dean of the University of Alberta Law School. I asked for information. He wrote back and said, "You're accepted." So those were easy days. Had it not been for that, I probably never would have got into law. I probably never would have met the exacting standards that I know most of you have met. Nevertheless, once I was in law, I realized I loved it because it offered for me a wonderful combination of theoretical problems, intellectually stimulating work, and interaction with real people in the community. And I think that's what makes law so special. It is an intellectually challenging study. And the problems with which I and my colleagues grapple daily are enormously complex and difficult sometimes. But it is always focused on real people, real concerns, real businesses, and this gives it a heightened relevance, and I think a heightened sense of importance that attaches to every decision you make, every position you take, whether you be a lawyer, an advocate, or a judge. So I have had a wonderful run at it. I was very fortunate to be asked to go on the bench at a fairly young age after a career in litigation and some teaching. And I was quite surprised when I was sort of asked whether I'd be interested, and I had to think about it a long time because I was enjoying what I was doing. And I thought of judges as somebody like I am now, old, mature, etc., etc. But after some thought, I decided I would go on the bench. And as you heard from Zach, I think that they were looking for women to push up rapidly or something. But anyway, when I was appointed at the Supreme Court of Canada in 1989, the Treasurer of the Law Society of British Columbia introduced me as the person who had made it through the judicial system faster than most cases, which was true. Perhaps not most cases, but some of the more complex cases. So I resolved thereafter to devote my life to access to justice. But that's another story on the side. We do need to get our cases through faster and at less cost, and we're working very hard on that. So I've had a wonderful time now, 23 years and a little bit more on the Supreme Court of Canada, and it's been an enormous pleasure to serve there in so many ways. As you know, our court is a final court of appeal for Canada, and unlike the American system where you have a federal system and a state system, and the top of the state system is the appellate court for the particular state, we don't have that division in Canada, and the Supreme Court of Canada, theoretically any case that starts out in any court could end up in the Supreme Court of Canada. But most cases go through trial courts, appeal courts, and end there, if not before. More and more, many disputes are settled through tribunals and the administrative law process. Only a few get to us, and how do they get there? Well, our criteria under the Supreme Court Act, as you may know, is that we take cases of public importance, issues of law of public importance. That's the criteria. And apart from a few criminal law cases, chiefly where there is a dissent on a question of law in the Court of Appeal, all cases that come to us are with leave. There's one other exception I should mention, and that, of course, are references from a government. You may have heard about the securities reference or the reference on the secession of Quebec and so on. Governments can refer either existing legislation or other legal questions to a court of appeal if they wish, or even a trial court. But often the federal government in particular will refer questions, if they choose to do so, to the Supreme Court of Canada directly. Now, this is not the main part of our work. We might get a reference once every year or two. So what we have are these cases coming through a leave process, which is mainly in writing, and we sit in panels to initially screen them, then we discuss them, and we decide in the end which cases to grant leave on. We have about 600 or 700 applications a year, and we tend to grant around 10 to 12% of those. Not that we have any quotas, it just works out that way. If it's an interesting question, we take it. And people sometimes wonder, well, you know, are you refusing leave simply because you're too busy? That has not been the case at any time since I've been on the Supreme Court. We take the interesting questions and the interesting and public questions of law that touch the public interest. That doesn't mean it has to be across Canada, but it means that it has to be of public importance. So we get the cases that we're going to hear resolved by the leave process. Then people file factums, and the case moves ahead. Law clerks do memos, and the judges prepare. We read the factums, we read the judgments, we think about the case, we go in to hear the case. After we hear the case, and we use the hearing process, I don't know if any of you watched, we stream it on the web, and you can pick it up anytime you get bored with your professor. If you have your computer in front of you, if you're allowed to. Not that that would ever happen at Western. But, and we are broadcast on CPAC after the event. So it's easy to find out what our hearings are like. They're fascinating, for us anyway, because we get a chance to interact with the lawyers. We get a chance to ask questions, to test points, to try out ideas, and it's a great experience from our perspective. We hope it's a good experience from the lawyer's perspective. Those of you who will appear in the Supreme Court of Canada, I know that it can be a little daunting the first time, but we like to think we're very friendly and nice and warm, and no one has any reason to be intimidated at all. Then after the hearing, we all meet in our conference room. We have a big round table, and we discuss the case. We go around after some initial discussion, usually beginning with the junior member, and talk about how we would dispose of the different issues and the case ultimately. And then at the end of a 2-week session, the Chief Justice assigns writing for the majority, and away we go. Ultimately, reasons are produced, they're exchanged, They're revised. There's lots of memos going back and forth, lots of discussions. We work toward minimizing our differences as much as we can. I think that's our job. Our job is to try to clarify the law as much as we can. We don't want judges going off unnecessarily differing on matters which could be resolved if they really sat down, talked about it, or even left for another day. But inevitably we have dissents, and we prize the right of dissent. And at the end of the day, every judge has to be satisfied in his or her conscience that what they're signing on to is something that they believe in, that they think is a good statement of the law and properly resolves the issue. So that is basically the way we work. Of course, as a federal institution, everything we do is in dans les deux langues, en français et en anglais. That means that there are translators in the courtroom, so that French to English, English to French, depending on what's happening. And it also means that all our judgments have to be issued in both languages. If it were an emergency, we could issue in one language, but I don't think we've done that for many years. It sends a very negative symbol or message. So this is basically how we work. I thought I'd say a few words about clerking at the court. I hope some of you will apply to our clerking program. It is a year with a few days off for holidays. It's hard work. It's exciting work. Many clerks, let me put it that way, and I've heard this so many times that but I am continually astonished. They may be out successful lawyers 15, 20 years, and they come back and they say, this was the best time of my life. The friends I made there were the friends I still have. The experiences I had were so wonderful. It's a little bit like a timeout, because you're starting, it's not like you're in your articles for a firm and you say, I've got to make an impression or I won't be asked to stay on. Everybody knows they're going at the end of the year. But they work very, very hard, notwithstanding. And I think develop very good and close relationships with the justices. And I know, speaking for myself, and I know this is the case with my colleagues, we really value not only the work that the clerks do for us, but the personal relationships that we develop with them, the fun we have with them, the new and bright and fresh ideas we get from them. I keep having to say, though, you know, you've got to go back to the record. That would be lovely to decide this case that way, but we have to base our decision on the facts in the case, the evidence in the case, and the issues before us. Oh, yes, but there's this new scientific evidence. If you just thought about that, that would solve the whole problem. And sometimes the public doesn't understand that either. We recently, I don't talk about cases, but just to make this point, we recently issued a couple of cases on the criminal law provisions on sexual assault in the context of contracting HIV. And there was all sorts of editorial comment, this is sounding a bit defensive, but saying, well, the court could have solved the problem this way and that way and the other way, but we were stuck with the record and the scientific evidence that we had. And that is the reality of judging. We can't just go out there and say, like philosopher kings, this is the best solution. Parliament can do that. They can go and gather the evidence and do what they want to do. But all the hype about judicial activism notwithstanding, we operate in a fairly constrained atmosphere.
Can you talk a little bit about the uniqueness of the way that judges live? Sort of, most of us have like a professional sphere, a personal sphere, and a social sphere. And the issues around the leaking of photos from the Manitoba judge seems to have brought into a lot of questions the role that judges are expected to play or not play in society or socially. what kind of pressures do you feel since joining the bench to have a professional life and nothing else, or a personal life and nothing else, but not really so much a society-based role per se?
Well, first of all, I think, and I'm not commenting on any particular case, but it's a fact that judges are expected to be at least people of good repute and people who are honest in the community and so on. And that's sort of an unwritten expectation, and actually in our judicial rules of ethics, because we have to decide cases that affect people's rights, and you hope that the judges send to the community and in fact operate with great, the message that they are ethical, concerned members of society. But there used to be this myth that judges couldn't engage in society. There was a shocked statement in British press about 60 years ago when a judge was observed coming into central London on the Clapham omnibus. I mean, people were just shocked. Judges had to be separate and above. That is no longer the case. We have, certainly in my time on the bench, it's been a clear recognition that provided they stay away from issues that might come before them in the courts and stay away from political issues and so on, that you can have a reasonable, you can have a private life and a social life, and you can even participate in community endeavors. Now there are limits. We had a judge a while ago in Toronto, a fine gentleman, but he got interested in something that his council was doing about zoning or something like that. And so he got involved in the debate and then didn't recuse himself, so that came before the judicial conduct proceeding under the NJI. So, you know, there are limits, and if you do, to the extent you might get involved, you might prevent yourself from sitting on a case. But we operate within that, and I find that personally, I very much like the outdoors, going to the cottage. I had my dogs for a time. Unfortunately, my last dog has passed away, and my husband says I can't have another, but there you go. And I like music, so I go to concerts, I do things like that. Other judges do other things. Some play golf, some do this, some do that. But we don't live a cloistered life. We do go to social functions and so on. And I'll just close on that question with something that the justice I replaced told me when I first came on the Supreme Court of Canada. It was Justice McIntyre from British Columbia. And I said to him, you know, do you have some advice, just one word of advice that would stand out amongst all others? And he thought, and he said, find some outside interests, otherwise this job will consume you. And that was very thoughtful and very good advice, because when you get into a job as difficult, as fascinating, as important as the job you do as a justice on the Supreme Court of Canada, it is quite possible to get completely swallowed up by it. And you've got to think, there are a couple of really good reasons for having outside interests. A, it's going to prevent you from going into a silo where you really don't have the perspectives you need to be a good judge. And B, it's going to save your life and mean that you don't crash and burn out after a short period of time. So that is very good interest. I've taken a long time to answer your question, but the answer is that we can have lives, but it's somewhat circumscribed. Yes?
Yeah, so to what extent can, I guess, you yourself or a judge in general allow their own political or personal beliefs to guide how they decide a case? And is it ever appropriate for a judge to decide a case based on their own personal positions?
I don't think so. I mean, the short answer is no. We have to, of course judges have positions, but the art of being a judge is to step back and impose what I call a process of conscious objectivity. And I know that sounds difficult, for people who haven't done it. But it happens, and I've seen it happen over and over again. So you step back and you listen to, you read what each party has to say, and you think about it. Consciously make an effort to think about it. And then you listen to what the different advocates say. And then you use your mind and your rationality as well as your instincts to test the various positions. And this brings you to a result that is not just your own feeling, as it might have been at the beginning of the case as to whether this conduct was good, bad, or whatever. It brings you to a legal result. And that is what we strive for. One of the things that I tried to do when I was a trial judge is, and sometimes it wasn't easy, to consciously put myself through an act of the imagination in the shoes of each of the parties before me. To try to see it through, they were there for some reason. They must have thought, maybe they were just there because they'd done something really bad. Those are the more difficult ones. But they were there for a reason. And so you have to try to see it from their perspective, even if it's a sentencing issue or whatever. How would they be seeing this? And where are they coming from? We have a fancy word for this, which you probably have to read too many times in reading our cases, which is context. But all that means is you're putting yourself in the position of the particular litigants or the particular people or victims who are involved in this situation. And judges are trained to do that, and the whole process leads us to do that. So that's what we try to do.
You've mentioned you've been on the Supreme Court now for 23 years.
Mm-hmm.
A judge for a lot longer than that. And I mean, I'm only 7 weeks into law school, and I've already read several of your decisions. And they're going to be read by generations of students years to come. But do you ever get to a point, after being a judge for decades, where in hindsight you look back at a decision and you're like, I actually don't agree with my own reasoning, or I wish I had included this, or I'm just wondering how you kind of deal with that, if that development comes, or if you're able to be like, you know what, all the decisions I've made over, 3 decades.
Everything is perfect. No, of course. I mean, my goal is to decide each case as honestly and fairly as I can at the time. But of course, you move on as a person, and issues move on. And sometimes you say, well, maybe we should have a second look at that. And that's all right. That's good. That's part of the process. And I've done that as well. Sometimes I've had a strong dissent, and then the majority was otherwise. Well, I'm obliged to apply the majority. But I recognize that everybody, dissenting or majority, is trying to do their best. And as long as the product is a reasoned product based on legal principles and every judge is trying to do their best, you really can't argue too much with the process. So sure, I think it would be awful to say I never changed my mind on anything, I never reconsidered anything. Personally, one does that. I'll be in court and somebody will cite a case I said and I wrote or whatever. Usually I agree with it, I have to say, but we do move on. Anyone else back there? No, that's why we have independence of the judiciary. I can just say a categorical no to that. Absolutely no. That's one of the beautiful things about our system of justice in Canada, and I believe that of other major Western democracies, is that we have this principle of judicial independence. And that means that litigants can come to court, and the government might be on the other side, but they know the judge is not going to be influenced in any way by whatever the government's position might be, other than what the good legal points the government brings forward are. But there's no other kind of pressure. And having visited courts in other parts of the world, developing countries particularly, you realize that this is not the norm. And it's the biggest problem that these countries face in developing a good justice system, because for many people, I've realized it's very difficult for them to even conceive of having a judge who would not in some way be responsive to the executive or whoever's running the country in a fairly direct way. But that is this wonderful principle that we have developed. Certainly came through very, very clearly in the development of British tradition, has been adopted by other countries like France and Germany and so on, of an independent judiciary that you can't have the judge removed because you don't agree with her decision. The person's salary is guaranteed, tenure is guaranteed, subject to good conduct, so that judges can be truly independent. And we must never, ever lose that. Yes?
I was just wondering, in the context of some new Supreme Court justices being appointed to the bench, and you having sat on the bench for 23 years, if you could provide any context to the periods of transition that must eventually come about when a justice leaves and is replaced by a new justice, and how that might change your consensus building process.
Yeah. I'll give a couple of little anecdotes and then try to answer your point about consensus. The first thing the judges usually say is, I got a modest increase in salary, and in some cases it's a decrease, but my hourly rate went way down because there's a lot of work at our court. There's an enormous amount of reading, and with something like 80 judgments coming through every year, plus all the leave work and so on, there's just a lot of cases that you have to spend deep and long hours thinking about and sometimes writing about. So it's that's the usual first response is, oh my God. And so I watch the new judges go into shock for a period of a few weeks, and you can see them thinking, how did I ever get into this? And then they usually just come out of it, they always have, and they realize that the quality of the work and the collegiality of the court and what they're doing is just so interesting and they get a hang of how to balance, keep all the balls in the air, and they relax, and everything is fine. So that's just one aspect, the adapting to the increased workload and the way you have to keep so many balls in the air. If you're in the Court of Appeal, you might have 3 or 4 cases you're worrying about at any given time of major import. In our court, it's just a lot more. And we are the final Court of Appeal, which puts extra pressure on. I used to like, when I was in the Court of Appeal, British Columbia, I'd think, well, I do my best, but if I get it wrong, somebody else will fix it up. But, we don't have that luxury. So, but you asked about the collegiality, which is a very good question. We have a very collegial court, and it is based, I think, on a real respect that each person has for the other person. And we work very hard, I work very hard as Chief Justice to make sure. I think my main job as Chief Justice, apart from the jurisprudence and things that I hope I continue to do, but I have to ensure that every judge has what they need to function at their maximum as justices. And part of that, so I regard myself as there to help them, to make sure that the whole atmosphere is one in which everybody feels empowered, everybody feels able to say whatever they want and say it respectfully and so on. And so we can have this real interchange of ideas on difficult points. And that's not always easy. We have 9 people. They often have very different approaches or views at the outset and sometimes in the end. And they have to maintain collegiality, notwithstanding the fact they can have passionate differences on questions of law. But that is actually what, so far, we have been able to achieve. And one of the things new judges say is they quickly test the waters and so on, and if they feel that the other judges are there for them, to help them, and the justices are all great about helping to help a new judge settle in, they quickly get on side, and it doesn't take very long. So we work very hard on the collegiality aspect of it, and so far it's working. I'll take Zach, and then the man in the red shirt.
I guess we're at completely different ends of the spectrum. You're the Chief Justice of Canada, I'm just a law student. But if you had one piece of advice for someone in my position right now, what would it be?
Oh boy. Well, I would, it's hard to get it down to one, but I think if it had to be one, I'd say just maintain a passionate feeling about the law and the legal work you're doing, because everything else, and if you're not feeling that, then look for something else, because the law is a broad umbrella in which you can do many things. So if you go into, let's say, you think I'm going to be the greatest copyright lawyer ever, and you get in there and you're not enjoying your day-to-day work, well, maybe you find another. I think passion lies behind it all. The people who are the really good barristers, the people who are the really good, you name it, are the people who are really into what they're doing and enjoying what they're doing and caring about what they're doing and seeing it as worthwhile. And seeing it as worthwhile not only to themselves in terms of making a living, which of course is important, but seeing it as contributing to the broader community. So I would say find a place where you can work, where you can get satisfaction, not just for yourself, but satisfaction in the sense that you think you are contributing to Canada, to the institutions here. It could be in any area, but make sure that you have that in your life. And I think if you have that approach and you get yourself in a situation where you can do that, everything else will fall into place. You won't worry about working long hours once in a while. Your work-life balance will work out. And at the end of the day, you'll say, I've had a great run, and I've contributed to my community, contributed to my legal profession, contributed to the legal fabric of Canada. Yes, next.
I was hoping that you could comment on the Etobicoke Center decision, specifically with regards to how it's going to impact the administration of elections for years to come.
Well, I can't, I have a lot of rules, but one of them is that I can't comment on anything that's going to come before the court, and I never comment on decisions that are recent, because what happens if you do that as a judge is that people say, oh, well, this is what she really meant, and that then becomes part of the jurisprudence. In fact, our reasons have to speak for themselves. And I just hope that the decision, it's a difficult decision, and I hope that it advances our understanding of how elections should be run in the end. It's a process, and the Elections Act has seldom come up before the courts, so I think we have two good decisions in the majority and the minority. I think they explore in a meaningful way some very difficult issues, and I'm hoping that will contribute as we go along to better democratic practices. But beyond that, I won't get into the details. Yes, back there.
I'm still in my undergraduate, and I'm deciding if I want to go into an MBA or a law degree. Where
You can do both.
I didn't quite get the last part of your question, sorry.
I'd like some personal advice on what you think law can do for me.
Well, it's done a lot for me, but I mean, I'd have to know you, I'd have to be a career counselor. And this is a really serious question, and I wouldn't answer it off the cuff without knowing you, your values, etc. But in very general terms, the law offers, and I can't speak to MBAs because I don't know that area, so maybe you should go there and ask them the same question and make up your own mind. But I think the law offers a way of thinking and resolving problems that is absolutely unique and absolutely essential to the world. We were saying this earlier over lunch. I've heard this from non-lawyers. Lawyers, people trained in the law, develop a unique ability to take a whole lot of data, a whole lot of conflicting rights and wrongs and positions, and work through them and synthesize them and get to the point figure out where the core of the problem is, figure out what the essential facts are, or whatever. It is this power of analysis and synthesis that your legal studies will instill in you in law school, and that you will continue to develop as a lawyer. So lawyers are basically, as I see it, problem solvers. And whether you're in mergers and acquisitions, or you're a litigant in a criminal law court, or a civil law court, or you name whatever it is, people come, corporations come to lawyers because they are either anticipating problems and they want to do the planning for it up front, let's say a corporate lawyer planning for the future, or they have a problem. And the lawyer brings this unique ability to look at all sorts of things and say, this is what you should be doing. And so if you're interested in that kind of thinking, that kind of problem solving, that kind of, I'll take these skills I've acquired and apply them to some new area, then that's something you will really enjoy the law. Back there, lady back there.
What has been the most complex and interesting case or question that's been posed to the Supreme Court while you've been here?
I never can answer that question. I get asked a lot. It's usually the last case I was worrying about. Different questions have different areas of complexity, you know, and it comes at you in different ways. You can get morally complex questions, things involving, you know, like the right to suicide or something like that. Not so hard to actually get your head around what the issue is, but morally extremely difficult to come to grips with. You can get complex regulatory problems or procedural problems which present quite another kind of challenge. Just understanding what I was just talking about, what is really going on in this area of human activity, and how do we get the right decision for that activity which balances various conflicting values and so on. And that's really challenging too. Sometimes I have to make decisions in areas that I've never really had much to do with before. It could be a judge has to go into a case on a complex biomedical file or engineering file where the scientists are lined up and the judge says, oh my God, I never did biochemistry. What am I going to do with this? But that's part of what I was talking about. If you're a good judge, you have to be able to get your head around the essence of the problem. You have to be smart enough to do that. And then you've got to be able to understand and try to bring it toward a solution that will make sense in the real world of the litigants who are up before you and the Canadian public who will be affected by it. So there are many different kinds of challenges, and I must say a lot of our cases at our level are really challenging in both those senses, or in either one or the other. Yes?
Are you in any way concerned about the decreasing number of women at the Supreme Court of Canada?
Well, I'm hoping that we will obviously maintain our numbers, and I like working in a mixed gender atmosphere, but it's not just about me. I think it's about this message it sends. It's about the perspectives that women, and I'd like to see more ethnic and racial minorities on the court too eventually. Now if we could, but you know, it's not always easy to achieve exactly. I'm not in the appointing business, of course, but I like having a diverse court, let me put it that way. I think you get better perspectives, and I think the court better reflects the Canadian community. And this engenders public confidence. I sometimes tell a story about when I was a trial judge, and there was only one man in the courtroom. It was a family matter. The only issue was division of property. And I was the judge, and the court reporter, court clerk, the wife, and her lawyer were all feminine. And so after the wife's case went in, I invited the husband, who was not represented by a lawyer, to tell me his side of the story. And he seemed to be having trouble getting up. And I thought it was because he didn't have a lawyer. So I said, it's not a very complicated case. I really just need to have your side of the story so I can make my decision. He finally got up and he looked at all the women around the room and he said, well, frankly, Your Honor, I feel a little outnumbered. And I assured him that the fact he was a man would not be held against him. And in the end, divided the property 50-50. But I went home that night and I thought, how many times throughout the years, if they ever got that far, did women stand up before an all-male bench and feel a little outnumbered? And it gave me a new perspective on it, to see it from his point of view. And I think that's why I say I think women on the bench add to the public confidence of those women who stand up before the court and no longer feel outnumbered, don't feel part of a minority up against what they may perceive wrongly, because men are just as capable of getting into the reality of a woman's life, I think, as a man. But and the other thing is, there can be perspectives that are brought to the table that get left out in an homogenous group, whatever that group might be. You want to have diversity. You want to have both genders. You want to have people from different backgrounds and different areas of the community, if you can. Yes?
Yeah, so I think many in this room would agree that moving in law school, we've come before some benches that have been quite quiet and passive and only asked a few questions, and then a lot of us have had the other experience, where it's more akin to being in front of a firing squad. So if you were to characterize the Supreme Court, how active are you guys when you're hearing a case? Do you ask a lot of questions? Are you more passive?
We ask quite a few questions, yeah. I don't think we often, it's rare that, I don't think ever, there'd be a hearing without quite a number of questions. And that's because we have already absorbed all the written material. So we've read the factums, we've had a memo from our law clerks, maybe we've talked to our law clerks about it, we may have even talked to each other a little bit. So we know where the problems are, we know what the facts are, we know what the principles at issue or in conflict are. So we don't need the lawyer to stand up and start off and say, well, A went to B and then this happened. We know that. Nor do we just need a recitation of what the law is, nor even a recitation of what the position is, because it's in the factum, presumably. And I put a great deal of emphasis in, if I talk to people about good advocacy, of the importance of written advocacy, which is in your factum. Because that's where you probably will win or lose your case in a lot of situations. So what's the oral part of it there for? The oral part is so that we can ask questions and you can satisfy us. You should be happy, an advocate should be happy if they're getting questions, because that means the court is involved and the court has questions about the ramification, about the validity, about how it fits with another principle, maybe a question about the facts in some cases, although usually that's been ironed out at our level. So welcome to questions, and when you're answering the questions, view it not as a firing squad. Take your position as something someone who's being fired at would not normally do. Say, how can I help the judge? Because that's what you're there for. And I say to young advocates, ask yourself before you go in, tell yourself, I want to be of help to the judges. It'll kind of demystify everything. That's what we're looking for. We're actually looking for help. And I can't tell you how many times after the big doors shut and we go back and a judge will say, well, that was really helpful, the submission of Miss X or whatever. And another one will say, oh, it wasn't, that other submission wasn't very helpful at all. So that's how we're looking at it. And of course, in any communication exercise, even one with a lawyer and a judge, you got to be thinking about your audience. Your audience is here, the judge. What do they want from you? They want help. They want to be sure not only of what your position is, but why they should go that way, whether there's going to be problems if they go that way, etc. So most of the questions are coming from that end. I don't think we have really argumentative, you might think I'm wrong, I don't know, but sometimes it gets a little argumentative, but personally, I think most of us are really just trying to test the position. So maybe the judge is just testing it. If you can't answer it, maybe there's some problem. So regard it as in that light. Well, it's been lovely talking to you. Thank you so much.